I'm Ben Meiselas from the MeidasTouch Network. Special Counsel Jack Smith just delivered another smackdown on Donald Trump's lawyers in federal court, this time in the Washington, D.C. federal court case where Judge Tanya Chutkan is presiding, and Special Counsel Jack Smith's team states in a brief that they just filed in opposition to a bizarre and completely unlawful request by Donald Trump's lawyers to try to get access to CIPA Section 4 documentation. That's Classified Information Procedures Act documentation. Its Special Counsel Jack Smith points out in schooling Donald Trump's lawyers in this opposition that there is no case law in the D.C. Circuit or elsewhere that substantiates anything that Donald Trump's lawyers are requesting. And Trump's lawyers are requesting the extraordinary relief, which is not countenanced in CIPA Section 4 litigation, to be able to participate in the ex parte in-camera court proceedings to review the classified documents, or at least portions of the briefing regarding classified documents that are relating to the Washington, D.C. case. And they claim, look, Judge, we only want to look at it on an attorney's eyes only basis. Trust us, Judge Chutkan. We are not going to share it with Donald Trump at this stage. And Special Counsel Jack Smith says, hold on there. Let's just go through what CIPA Section 4 is. Let's talk about the relevant case law in the D.C. Circuit Court of Appeals. What Donald Trump's lawyers are asking for is completely devoid of any legal support. And then Jack Smith proceeds to just step-by-step take down Donald Trump's lawyers. We'll go through that in just a moment. Just to refresh your recollection, MeidasTouch Network watchers, you know that CIPA stands for the Classified Information Procedures Act, and it sets forth a whole host of procedures in how you handle documents, classified documents in criminal cases, because, of course, criminal defendants are entitled to discovery of documents from the prosecution, and they are entitled to what's called Brady material that tends to be exculpatory. The government is required to turn that over. But what happens in a criminal prosecution where there are documents that may be highly classified, highly sensitive, where showing those documents to a criminal defendant poses a national security threat? In that case, the CIPA procedures kick in again, and they kick in general of how you handle classified documents. Where can you review the documents? They have to be reviewed in SCIFs, sensitive compartmented information facilities. But what happens where there's a document that's so sensitive, the government says, you know what? The national security interests here outweigh the relevance and helpfulness of this specific document to the criminal defendant. So is there something else we can do, Judge? Can we withhold that document under CIPA Section 4, perhaps replace it with a summation of what the document stands for instead of turning over the document itself, because the national security interests here far outweigh the relevance and helpfulness to the criminal defendant in this specific case? And the way this goes down in all of our courts is it's done on an ex parte basis. It's written in the statute, CIPA, Classified Information Procedures Act, Section 4, and it says what goes down. Like, it's pretty clear what you do. And by ex parte in camera basically means the criminal defendant and the defense lawyers aren't involved in the proceedings. What it is the government makes a showing to a federal judge. The federal judge reviews it on their own outside of the presence of defense counsel, and then makes a determination about if it satisfies the standards for CIPA Section 4, and then fashions a remedy of, should there be a summation of the documents? Should the documents actually be turned over to the criminal defendant, or something else? But the criminal defendant's lawyers are not involved in that process. And one of the things Judge Chutkan did, though, with a little degree of sarcasm, is initially when Donald Trump's lawyers said that they wanted to be involved in the SEPA Section 4 review, even though they're not entitled to be there, Judge Chutkan said, all right, I'll give the defense, this is a direct quote, an opportunity to explain why it believes that SEPA, Classified Information Procedure Act, why it believes that SEPA's statutory text and our Court of Appeals circuit precedent do not govern this case. In other words, Judge Chutkan says, try to convince me, Donald Trump's lawyers, why the clear language of SEPA and why all of the things our Court of Appeals have said, why are you special? Explain that to me. But I'm open to it. Submit a brief. And Donald Trump's lawyers submitted a brief. It does not address what Judge Chutkan says. And so Special Counsel Jack Smith says, Donald Trump's team did not address what you requested. They misstate the law. They're just lying about things. They clearly don't know what SEPA is. They don't know SEPA Section 4. There's no reason to deviate from normal SEPA procedures. And also, as per usual, the economy was also a huge topic for the day. And why wouldn't it be? It's changing faster than ever and demanding we all adapt to keep up. In fact, a stunning survey revealed that over half of Americans making six figures now live paycheck to paycheck. Now, even though Goldman Sachs is saying that classic investments are headed nowhere for the rest of the year, other markets are rising to fill the gap, creating incredible opportunity among the chaos. Because even if conventional markets flatline this year, other assets don't have to do the same. That's why I'm so excited to introduce our next partner, Masterworks. I actually spent a lot of time digging into this, and according to a recent report by Citibank, the asset with the lowest correlation to the stock market of any major asset class was art. It turns out contemporary art pieces have outpaced the S&P's 500's return for the last 26 years by 131%. Now, this market used to be hard to get into, but Masterworks is the platform that lets you invest in multi-million-dollar paintings without breaking the bank. Masterworks has built an impressive track record of 15 exits, all of them profitable. These numbers speak for themselves. Now, with those kinds of results, Masterworks offerings have actually sold out in minutes before. So there is a wait list. I've invested with Masterworks, and as with any investment, past performance is not indicative of future returns, and exited investments are not representative of performance for artworks not yet sold. But I reached out to them. I reached out to Masterworks to give you all VIP access to their latest offerings. To skip the wait list, head over to masterworks.art/Meidas. That's masterworks.art, ART/Meidas, or just click the link in the description of this episode below. That's masterworks.art/Meidas, or just click the link in the description of this episode below. Thank you, Masterworks. And now back to the show. Do we really think that Donald Trump's lawyers are arbiters of truth, competence, and integrity here? These were the same people that were arguing just the other day on Monday that a lot of Donald Trump's threats are perfectly acceptable. They thought it was fine. And ultimately, Your Honor imposed a gag order on Donald Trump. Here's what Special Counsel Jack Smith writes. Government opposition to second defense motion for access to SEPA Section 4 filing. And just to be clear, while technical, it's technically a lawyer on Special Counsel Jack Smith's team. I just want to be very precise. Tom Wyndham, the lawyer, wrote this under Special Counsel Jack Smith's authority as well. Here's what it says. In its memorandum opinion permitting Donald Trump, the criminal defendant, to move for access to the government's SEPA Section 4 filing, the court allowed the defense an opportunity to explain why it believes that SEPA's statutory text and circuit precedent do not govern this case. But the defendant Donald Trump's motion fails to provide any legitimate basis for the court to depart from the plain language of SEPA. or this court's binding precedent. The court should deny the defendant's latest attempt to intrude in the ex parte SIPA Section 4 process. So they go through the procedural history, and then Jack Smith's team says, let me educate you, Donald Trump, on the law. Sit back and prepare to be schooled. SIPA sets forth procedures at the pretrial, trial, and appellate stages of a criminal case to enable courts to protect defendants' rights to due process, including the right to a fair trial, and to protect the government's interest in classified information, sources, and methods. SIPA Section 4 authorizes the court to deny or otherwise restrict discovery by the defendant of classified documents and information belonging to the United States. Courts consistently have upheld the ex parte and in-camera nature. Remember, ex parte, basically the government on its own, in camera, just the court there, not the defense being involved in it. So courts have consistently upheld the ex parte and in-camera nature of such motions under the federal rules of criminal procedure. The ex parte nature of SIPA hearing does not unfairly prejudice the defendant. Indeed, as the D.C. Circuit binding precedent has commented, this practice is analogous to other discovery determinations that a court may make in camera on its own, or that prosecutors may make on their own. The standard this court must apply is delineated in definitive case law, and this court should not deviate from the case law at issue. Defendant Donald Trump's lawyers are seeking unprecedented relief, access to any unclassified portions of the government's SIPA Section 4 motion so that he can review and respond in additional rounds of litigation not contemplated by the court's order, but he provides no legal authority and no basis to do so. And let me break it down, Judge, why this is so dangerous. First, the defendant points to no cases at all which allow for the type of procedure that they are requesting. Second, disclosing to the defendants even unclassified portions of SIPA Section 4 motions defeat the whole purpose of the SIPA Section 4 procedures. Third, and relatedly, the motion's ultimate paragraph betrays the defendant's true intent to try to litigate the propriety of the government Section 4 motion, inviting the very sort of adversarial proceeding the D.C. Circuit represents. So, Judge, they're asking for access, but really what they're trying to do is attack the very nature of a SIPA Section 4 procedure at all. Fourth, the defendant misinterprets the case law in which he relies, and Jack Smith's being very nice there. I wouldn't say it's misinterpreted. In my opinion, it is just clearly providing incorrect case law. Fifth, since the defendant seeks only unclassified information, his contention that he should receive such information because his counsel have security clearances completely miss the mark. And so Jack Smith just slices and dices and schools Donald Trump's lawyers. And there you have it, folks. Very confident Judge Chutkan is going to deny Donald Trump's lawyers' request here. SIPA Section 4 proceedings are going to take place as they always do. And it's interesting here because this is the Washington, D.C. case, not the Southern District of Florida case. Southern District of Florida case is the case involving Trump's theft of classified records. But here in the Washington, D.C. federal case, it involves Trump's attempt to overthrow the results of the 2020 election. But there are highly classified documents that are potentially related to the case. And so that's why Jack Smith is holding these SIPA Section 4 proceedings, because of those documents as well. Trial scheduled for March of 2024. Buckle up, folks, because come hell or high water, Judge Chutkan said she ain't moving that court date. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We are on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. Have an amazing day.
Hey, Midas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.